We're back here to current patent and trade secret strategies for generating IP value and return. You have true experts in this matter, along with Brian, who I think will be with us, Brian Hinman, who a lot of you know, many of you know, and he'll be on the live stream. So, Efrat, why don't you take it away?
Thank you, Bruce, for inviting me again to speak at your conference. It's always a pleasure. Hi, everyone. I think I know about half of you. Here we are the local IP community. We travel together to conferences.
The local pro-IP.
Pro-IP community. Can you hear me? I'm not getting that. Okay, so today's panel, again, we had a bit of an intro going into this, but with the likes of Jack Dorsey and Elon Musk calling to the demise of IP law, we're here to investigate the current state of IP assets, like patents. We're going to talk about patents, we're going to talk about other assets and copyrights, and maybe reclaim some of the reputation of these very assets that we're all engaged in creating, managing, and in my case, valuing and monetizing. How bad is it really out there, and what can be done to succeed with IP monetization in today's marketplace? I'm going to start by introducing the panel, and I'm going to play the role of a moderator speaker today, so I'll chime in with my comments as well. As I mentioned, my name is Efrat Kasznik. I run a company called Foresight Valuation Group. We are a Silicon Valley-based IP valuation consulting firm. I'm also a lecturer at the Stanford Graduate School of Business, where I try to teach business students at the GSB, the Graduate School of Business, how to treat IP right as a strategic business asset and not just as a legal predicament. I'm also very involved with LES, Licensing Executive Society, who is a sponsor or a partner of a CIPU, and we co-promoted each other's conferences. We just had our conferences a week ago, talking about the Silicon Valley deal machine. Yeah, and I have more than 25 years of IP consulting, working with companies of all sizes across all industries at this point. I used to shy away from life sciences, but no longer. And just trying to bring more intelligence, I would say, and as measured in dollars and cents, but also in strategy, into all sorts of transactions like licensing, M&A, selling, buying, a lot of value IP for funding that we're doing recently. So that's a little bit about me, and I'm gonna pass it on. I'm gonna introduce the panel members by name and title, and let them introduce themselves. To my left, I have Louis Carboneau, CEO of Tangible IP. Louis, would you like to introduce yourself?
Sure. Thank you. Is this on? Yeah. Sorry, I just flew in and my ears haven't popped up, so I can barely hear myself. Hopefully you can hear me. Good morning, everyone. It's a pleasure to be here. So coming from sunny Seattle this morning, and getting into what feels like winter here. So it's a pleasure. I think I've known Bruce for many, many years. We've done a lot of things together in terms of, podcasts and all this, but this is really the first time I'm, able to attend this. So it's really a pleasure to see you all. And I recognize a lot of familiar faces indeed. As Efrat mentioned, I'm the founder and CEO of Tangible IP. We are a patent brokerage firm and also a strategic IP advisory firm. But we're, I think, more known for our brokerage activities. We're probably one of the leading brokers worldwide, having successfully brokered, we're closing on 6,000 patents. And a lot of those are, very small transactions. So it's a lot of closing. We close about a deal every month on average. And we've done that for the last 12 years. Prior to that, I was the general manager for IP licensing at Microsoft, where I spent 15 years. And prior to that, I was an IP litigator. So I've kind of been in this industry now for over 35 years, I think. And I also publish a newsletter called IP Market Updates that a lot of you receive and that is read by over 20,000 people in the IP community. It's free. So if you want to know what's going on with this kind of asset class that we call IP, you're welcome to subscribe. and I look forward to our discussion.
Great, thank you, Louis. To Louis' left, we have Nathan Shaffer, a partner at Orrick. Nathan, would you introduce yourself?
Yeah, of course. So I'm an IP litigator at Orrick, Harrington, and Sutcliffe. We have a big office in San Francisco. My practice does not focus primarily on patent work. I do some patent work, but I tend to take complicated cases that involve technology, and most of my cases have a mix of IP, copyright, trade secret, patents, trademark. I've literally had 2 cases in the past year that have all of those things together. And I operate both on the plaintiff and defense side, so about 50-50. And I've just got a number of matters going today in the space, both enforcement and defense side. So I'm fairly aware of what's going on in the law and what the current state is.
Were you involved in Oracle v. Google?
I was involved in Oracle v. Google, yeah. So I was on the trial team for that case. We were on the side that did not prevail. So I'll print disclosure. But yeah, so through that case and additional work, I know quite a bit about software copyrights, protections, enforceability, and fair use, which is now becoming very, very salient in the AI space.
Thank you, Nathan. Last but not least, we have calling in from, I don't know where, Brian Hinman. Brian needs no introduction, but a formidable force in the world of IP, formerly with Philips, IBM, InterDigital, Aon. Please introduce yourself, Brian.
Yeah, hi. Nice to meet everyone. Sorry I couldn't be there in person. I'm based out of Houston, so I moved from New York to Houston back in March of last year. I took the role of Chief IP Officer at a company called Cody Global. So what we're doing is providing kind of an extension of what I was doing at Aon, which is providing IP-based lending to provide access to capital, a mix of debt and equity, to growth stage companies, so post-Series A, Series B companies that are operating in the tech space. And they have an strong IP base. And, to the point others made, it's not necessarily patents, but it's a mix of patents, trade secrets, trademarks. It's the entire spectrum of IP that mirrors that revenue stream. And we provide that capital to these companies. Prior to that, I was doing a similar role at IBM. I was the chief commercial officer of their IP solutions practice. Prior to that, I was the chief IP officer and CEO of Philips Intellectual Property and Standards based in Eindhoven at their headquarters at Philips. Prior to that, I was the head of IP at companies like IBM, InterDigital, Verizon, and I was the founding CEO of Allied Security Trust and the co-founder of Unified Patents. Nice to see everyone.
All right, let's dive right into it. So when I asked Bruce, what would you like us to discuss? He said, why don't you try and talk about the question, how reliable are patents? And you use the word reliable. In traditional licensing and monetization models. So there's a lot of talk about that. And I would actually like to start with you, Brian, because in our prep session, you had some strong feelings about the term reliable. Can you
I don't like that. I don't like the word reliable because patents are always going to be a viable source of value for companies. And companies shouldn't shy away just because maybe they're afraid the patent system is going to invalidate one of their patents, but it's all about quality, right? And so patents, I think, remain a very viable source, like I say, of that value. And from a licensing perspective, most certainly it provides that value. Is it a different licensing world that we live in now versus, say, 20 years ago when I was, raking in $1 billion a year at IBM? Sure, it's a different world. Companies have, they're not as, apt to agree to licensing terms perhaps as they were back then, but suffice it to say, with good quality patents, they can be used, and Louis will agree with that, because you can do everything from buying and selling patents, used in an M&A context, used in a borrowing context like I do, in a lending context. So there's certainly a lot of value.
Louis, do you agree with this? And what is your take on the reliability of patents?
I think the concept of reliability is important here, but I don't think it attaches to the patents as an asset class. It attaches to the legal environment that's being created around those that has become unreliable or unpredictable in the past decade. think of a patent as an asset class that you invest in for 20 years first. So obviously there's going to be a cyclical process where, there are years where they're worth a lot more than others, given, that the goalpost may be moving. And we've seen this, and Brian alluded to that 12 years ago before, IPRs and before Alice, it was a lot easier to transact patents and valuations were much higher. Then the legal environment changed, not for the better in the US at least. And as a result, valuations came down and it was flight to quality, as it should always have been. But, instead of having maybe 10% of patents that could be transacted, we came down to 1%, where we're kind of still stuck these days, if you look at it. We review about 5 portfolios every single day that people want us to broker, and we probably take 1 portfolio per month only that we will broker, and we don't necessarily sell them all. We've got a pretty good batting average, but they're really hard to monetize because of the environment that has become quite unpredictable. Now, there's kind of a light at the end of the tunnel, I think, and I think I've mentioned before that for the first time in many years, I'm fairly bullish on this asset class because the big clouds that have been over our head for the last 10 years are starting to dissipate a little bit. First, there's been the advent of the UPC in Europe that has created new momentum and, kind of instilled new value in patents as long as you have the European counterparts. And then we've seen recently what's going on with the IPR. The IPRs might become a little bit of might go the way of the dodo if we see the latest, tea leaves in terms of, discretionary denials that have been expanded greatly. It's a little bit too early to tell, but I think we're going in a direction where there will be a lot less fewer IPRs instituted, and that's good for patent owners and bringing more predictability in the system. And then we see that all the bills that are in Congress currently are pro-patentee bills. And there are 3 of them. So if only one of them passes, it will be very important because it will either, end up the IPRs completely, or it will clarify eligibility, or will bring back injunctive relief. So either of these 3 or a combination of these 3 would be even better. So I see a lot of good signs that this asset class may finally be in a more reliable environment. The patents have not changed. The environment has, and I think it's changing again for the better.
You've heard it here first from the tea leaf. So, Nathan, in our prep session, you mentioned something about the use of AI making it more difficult to enforce patents. Would you like to elaborate on that?
Yeah, so we are running into an issue, particularly at the startup phase. So my practice includes representing companies throughout the life cycle. We have startups that haven't even formed yet through blue chip technology companies. And I think there can be a lack of understanding on the founder side as to what makes a protectable piece of IP, given that there is a human authorship requirement in copyright, and there's a human inventorship requirement in patent. And when companies are first starting out, depending on when they come to us or come to another firm that has this expertise, they may or may not have the advice necessary to protect their IP. It can become an issue in diligence later. So one of the things that we're seeing is that in diligence for funding or acquisitions, the acquirer, the outside party, wants to know how the IP was created and how enforceable the IP is going to be. A patent or a copyright could be invalidated or made more difficult to enforce or more complicated to enforce if there's not a clear record of how the IP was created, either invented or authored by a human being.
Great. So just from my point of view, the IP community is extremely agile. So I think it's one of the most agile communities that I've seen when it comes to responding to patent challenges. There's other IP assets other than patents, but patents is the most tradable. And as I tell my students, it's the most tangible, intangible. And really, what we see, a couple of things. First of all, people tend to blame patents only when sometimes there's other contributing factors, such as the underlying technology, which we've seen waves of technologies that may make patent more valuable or less valuable, regardless of the legal protection of patents. The other one is the industry. Like if you're in a pharma biotech, you live and die by the patent. and those, whatever legal challenges, the patent work really well for this community. On the tech side, software, others that, where there's less R&D usually. This is where I think you hear most of the complaints. The business model is really important too, and that's actually kind of a good segue into our next topic, which is what happens in the market is the response to maybe changes in the perception of the strength of patents leads the industry to respond and really what's changing are the risks and the economic opportunities associated with patents or other assets. We see the industry usually responding in 3 different ways, and that kind of takes us to our next big topic, and how does the industry respond to that? One is the change in traditional business model. The other is the emergence of other types of IP, and the third one is different strategies across the life cycle. I would like to start with the business model question. My experience, I've been in this business for over 25 years. Every decade has a new IP business model that's kind of the leading model of the day. In the early 2000s, when we kind of started really looking at monetizing IP more seriously, I would say, and that kind of overlaps with my career, that kind of started around that time. There was a lot of non-core licensing. So everybody was waking up to the Rembrandts in the attic, for those who know the book, and everybody was looking for large companies with huge patents. Where are all those hidden gems that we're not doing anything with? Let's go and license them. Things have then developed into the next decade, which I would say the 2010s, where we saw more of the sophistication of the industry. So more capital came in. We saw the rise of intermediaries, rise of NPEs, whether you like the name or not. And enforcement was kind of the king of the day. That kind of went away a little bit due to circumstances beyond the industry that had to do with legislation and the courts. And where are we now? So I'm seeing a lot of leveraging IP for funding more than anything else in a lot of very creative ways that I'm happy to talk about. But I would like to pass it on to the panel and ask you, Louis, as one of the most successful patent workers that I know, what are some mistakes to avoid if you want to make patents marketable and tradable? So if you were to continue what you're doing, what would you do differently today?
Yeah, thanks. That was a really good kind of overview of the history. And I said, it's very cyclical. And when I mentioned earlier that we see about 5 portfolios a day, we only take once a month, maybe. Most of them we don't take is not because the environment is bad. It's because the patents have not been drafted the right way. So a lot of that is self-inflicted, starting with patents that are either too broad or too narrow. A lot of issues done by patent attorneys who will draft the invention, but will not think about, okay, how do we design around these things and try to, obviously predict that and claim that as well. So a lot of these patents, you look at them and say anyone can design around those fairly easily. So even if there might be some infringement, if there's only a little bit of past infringement, and we know it's going to be very easy for any infringer to design around and change that and stop infringing tomorrow, then obviously you don't have the same strength in terms of really, going after them and say, you guys, you're stuck with that design, you're going to have to pay a licensing fee. So there's that. A lot of indefiniteness issues, a lot of lack of support in the claim, lack of support in the spec, respective to the claims. So many times it's just bad work product. And unfortunately, we live in a world where patent attorneys draft patents for clients that don't really understand the work product. And they basically sit on a patent and they think that all patents are created equal. And I often compare patents to a backup generator. You buy it and you can be 2-3 years without using it because you don't lose power. And then the day you try to fire it, it won't start. Very often patents are the same. The minute you need them is when you realize they're full of flaws. And someone will tell you, well, you didn't do any prior art search. Well, I was told that the examiner's job was to do that. But then, after half a day of prior art search, you realize that you never had an invention in the first place. And yet you paid $50,000 to $250,000, you know, to build a portfolio that is a house of cards. That's probably the biggest mistake I see, is just people not putting the time and money up front, doing a prior art search, which is very inexpensive. You can do that for a couple of $1,000, and you'll save tens, if not hundreds of thousands of dollars, because it's the same price to get a bad patent as it is to get a good one. So if you just do this, and maybe you have a second pair of eyes looking at your patent and the claims, and understand what you're trying to do is really creating barriers to entry, not just translating an invention into a patent, because that's not going to do you any good. I mean, unless you really only want to prevent the cloning. But if you really want to expand and have something that creates a barriers to entry, you have to think strategically at the drafting. You have to maintain that portfolio. You have to file continuations to keep it alive, because someone might think of something that you didn't think of, and if you have sufficient support in your spec and you have an open continuation, then you can address it without having, you know, to go back to the patent office with some kind of reissue or re-exam. So all these things can be done and will increase tremendously the amount of patents that have, you know, assertion value, monetization value, irrespective of the environment. And that's probably something where people can help themselves just doing these basic steps.
Yeah, very well said. And I mean, I do a lot of, not a lot, but I do bankruptcy cases from time to time, and I always tell this horror story of, so at startups particularly, I think are very misguided, like this one software company that ended up with 300 patents, almost one in every country. That, like, who needs that, right? Like, had zero, no value. They couldn't sell the assets for a dime. So that's very true. Like, think ahead and design the portfolio and write the claims properly. Brian, you've been involved with companies that have pioneered, like Aon, that have pioneered some of the more creative IP tools in the industry. What are some of the changes that you're seeing in services and in business models around IP?
Yeah, I think one of the keys is something that Louis hit on, which is this 1%. It's really, you know, it's a general rule, but it's been the case time after time, year over year. 1 to 3% of any patent portfolio is actually worth something. So what does that mean, that it's worth something? I think the way that it's changed is the value, right? So the value, there's lots of sophisticated ways you can do the market income and cost method. You can do Black-Scholes analysis. You can do all kinds of discounted cash flow analysis to come up with a valuation. And what we saw at Aon, and where I'm seeing now, and, you know, particularly in a lending environment, that's not really where the value is, because at the end of the day, you can come up with a valuation using those methods that might be $100, $200, $300 million for your portfolio. But unless there's value in use, it's worth zero, right? In other words, if there's nobody doing what you have patented, or if you're not doing it, then what's the value to somebody that wants to buy it, right? He's going to want to buy it because there's value in it. And so there has to be value in use. And I think that's the kind of what's changed is really that perspective. And secondly, as a small startup, think about this, right? A small startup has, you know, they're trying to watch every penny. Every penny's a prisoner with a startup, and they're trying to see, okay, I'm going to do the perhaps I'll even do the analysis that you're recommending, Louis, on patents to make sure that patent is solid, and I got a good solid case for infringement. But the problem there, and now what we're seeing is, and I know if Adam Mossoff is in the room, he's written volumes on this, and it's one of the best writers on this topic of predatory infringement, right? So these companies have these patents, and they want to go out, and they feel they have an exclusive right, which is what the Constitution says. You have an exclusive right to exclude others, right, in what that patent covers. And the problem is, in courts, it's not that the case. You don't have that. You don't have that right. You can't get an injunction. You can't provide that. You don't have that threat. And as long as that threat is not out there, this predatory infringement issue is not going to be solved. So some of the, as you say, Louis, we've got some legislation that hopefully will pass to perhaps address some of this, but it's a huge problem. And we're seeing it time and time again with startups. And you know, I applaud Adam for the stuff he's written on him. So it's really having to do with the changing perspective on value, as well as the changing perspective on really what, you know, is a valuable patent, but at the end of the day, is it?
If I can just add to what Brian just mentioned, you just have to look at what's going on in Europe, in Germany, and now with the UPC, where they do grant injunctive relief, and it's been a game changer or even in some countries where people use strategically their patents, like in Colombia or Brazil or India, where they can get an injunction. And that forces, holdouts who just don't want to, pay anything to come to the table, because suddenly they cannot sell their goods. And this is the ultimate, obstacle for them if they're blocked from entering a market. And that's what gets their attention. Otherwise, we know in the US, whether you pay a licensing fee now or 10 years from now, after litigating and losing, it's going to be the same price. So why not, try to, just defer that as long as you can? It's like deferred taxes. So that's why it's been so easy and pervasive that, the serial infringers have just played the game, the litigation game. And we see a lot of litigation, not because NPEs are bad, but because NPEs are basically trying to have this licensing discussion, and it goes nowhere 99% of the time. And then they have to assert that that's pretty much it, And this is specific to the U.S. because we let the environment, become what it is now. So that's what needs to change.
Yeah.
I will add, in the US context, there remains the ITC, which is a place where you can get something that's very much like an injunction against foreign imports of infringing goods. Covers trademark, patent, trade secret, essentially all forms of unfair competition. It's not as cost effective as perhaps a jurisdiction like Germany, but it is still available as a remedy. And we do a number of those cases, again, on both sides, plaintiff and defense.
Yeah, I'd say it's the only alternative to having an injunctive relief in court. But an ITC case is about $10 million in legal fees, that you have to spend within a year. So it's not for everyone. And you have to obviously meet the domestic industry test. And you cannot even get damages from the ITC. All you get is an exclusion order that we know can then be appealed to the White House. And so it's not perfect. So that's why obviously, you always look at the alternatives. And currently the UPC and Germany and even other countries offer a much cheaper way, assuming you have patents in Europe. But obviously, who was thinking of having patents in Colombia 10 years ago, not knowing that, in 2024, it would start issuing injunctions. So in many cases, you have the right strategy, but you don't have the right assets because, some new phenomenon has sprout that nobody could really predict.
That's interesting about Colombia. I've learned something new today. Actually, Nathan, I would like to stay with you and talk a little bit about trade secrets, because I think one of the responses of the market, other than finding new litigation strategies, is maybe companies can rely more on other types of assets. I know you're doing a lot in the trade secret space, so what can you tell us about that?
Yeah, trade secret remains a natural protection for IP when a company is using AI to develop the IP. There is no human authorship. There's no human in the loop requirement for trade secrets. You just need to have something that's valuable because it is secret. It has to derive value from its secrecy. So it can cover things like a large collection of data. It covers things that copyright wouldn't cover, like sweat of the brow. Like I put a lot of effort in to collect this thing, and now it's valuable. And trade secret would apply to that. Trade secret would apply to inventions that you do not need to disclose publicly in order to practice, right? So you wouldn't necessarily need to get a patent. You could rely on trade secret protection. There are some limitations. It's harder to enforce. Like you can't enforce a trade secret against somebody who's done nothing wrong. Independent development or reverse engineering are complete defenses to trade secret protection. But if you are deploying AI and you're using that to generate more IP and you're benefiting from those efficiencies, then a natural thing to do would be to establish trade secret protection, make sure that you're developing all the elements that you need to maintain that in the future. And that's a way you can kind of fill the gap as you're benefiting from the efficiency you may gain from deploying an AI tool to develop IP.
Now, one of the things I've seen on trade secrets, particularly in the case of lending, again, I know Jim Pooley is one of the greatest minds when it comes to trade secrets, and I always relied on him whenever I had a question or something. And he and I have worked together in different cases before. But the DTSA was, and he was a large part, one of the authors of that. The DTSA changed the game with respect to trade secrets, and you really have to, but you have to play by the rules. Like you said, you have to be smart about it, right? You have to prove the existence of it, and you have to show that you've done reasonable efforts to protect it, right? Otherwise, the judge is going to throw it out, right? So as long as you play by those rules that are defined in the DTSA, and then as far as the value component, it's a lot of companies are saying, well, the patent claims are really conveying what it is. And so maybe, to a large extent, there's a budget constraint. So companies are shaving their budgets and maybe protecting a lot with trade secrets, but also, it's not letting out that secret of what they're doing, even though it doesn't convey the secret sauce. It to a large extent, patent claims will tell you what you're doing and what it embodies, your invention or your innovation. So it's another reason why companies are choosing to do that. But like I said, it does carry tremendous value, and we would value that every bit as we would a patent, as far as from a value perspective, because it's going to relate to either a cost savings maybe it's a method to save costs, or it's a way to increase revenue. That trade secret might be very much showing value from that perspective.
And keep in mind, you can get an injunction for trade secret misappropriation, and you can get a wide variety of equitable remedies, including disgorgement of the infringer's profits through a constructive trust or an unjust enrichment theory. So a lot of the limitations that you find in other forms of IP don't apply to trade secret due to the history of the claim and the nature of the IP.
That's great. When I advise companies on IP strategies, I always tell them, the best strategy is multi-pronged. So you don't want to rely only on patents. You want to rely on patents, trade secrets, copyrights, trademarks. Contracts are very effective. It's a lot harder to invalidate an exclusive contract for procuring goods or materials or distribution or something like that than it is to invalidate a patent. So people tend to forget about contracts, but they can be quite powerful. But going back to trade secrets, in the last decade, especially because patents have been a little bit harder to enforce, trade secrets have become more and more important. And think of the two big technology revolutions of the last decade. It's been essentially the cloud and AI. And these are two areas where it's really hard to detect if your patent is being infringed upon, because everything happens behind, a black box essentially in the cloud, or, if it's an AI algorithm, you won't know how it works, you just see the results. So why disclose all your basically good innovation through a patent disclosure if you're not going to be able to detect if someone is infringing? It's like publishing your grandma's chocolate cake recipe. A lot of people will do it in their kitchen. You'll never find out about it. So what's the value of making it public? So people they have to stop and think about what's the best mode of protection for these types of technology. And very often trade secret is a better one. Very often the best one is a hybrid. You might disclose some high-level algorithmic formula in your patent that you can detect, but all the optimizations, obviously, that are a little bit more trials and errors, should stay secret. So I think these are the best approaches, and in many cases, that's going to be a better way in terms of creating barriers to entry, because you're not making your competition smarter by disclosing all the good things you've done. You keep all your trials and errors and all the related data internally, and as long as you do a good job maintaining that secrecy, you can enforce it if you need to, and very often it will be against former employees or partners that maybe have breached the secrecy here. So the problem with trade secrets is a lot of people do a very good job creating the secret, but a very bad one preserving it secret, and I've done a lot of litigation in my previous life around trade secrets, and it's very fact specific, and it doesn't take long when you start putting people, deposing people to find out that, they became sloppy after a while, and they're all little things that, little breadcrumbs that they left where the secret was no longer a secret. But that's basically discipline and processes, things like that you can instill in the company if that's what they decide to take in terms of the direction. But trade secrets can be a very powerful tool, especially with the newest technologies these days that are very hard to detect from a patent standpoint.
Yeah, I want to say from a valuation perspective, people tend to think, trade secrets come up a lot in litigation. So you see a lot of the valuation is done in the context of litigation. But what people are forgetting, there's a lot of licensing, and sometimes a company will say, all we have is trade secrets. Well, you can, and most of the licensing that is done is technology licensing. And technology does not always have a patent protection on it. So you see, you can see both. You can see trade secrets can be licensed, can be valued. a lot of times because so the main difference from a patent is that with a patent, a patent is more tradable, so you can sell a patent. For selling trade secrets is a little more difficult because it comes with the people usually. So a lot of times when you see trade secrets sold, it's in the context of an M&A deal. So you sell the whole company with the trade secrets with the people. A lot of times, and I ran into it in a collateral situation where a company is collateralizing against a loan. There would be their patent portfolio and their trade secrets. And the lenders, who was my client, they wanted to value the patents and the trade secrets. And a lot of that was how can you transfer the trade secrets if you need to liquidate the collateral without the people? So I think that there's something about trade secrets. Yeah, go ahead, Brian.
No, I was just going to say to that point, what we did at Aon to kind of preserve that so that way you're not tied to the people is to document it, right? So we forced the documentation and we're very anal about getting with these companies and saying, document these methods, these ways to do a process or whatever the trade secret is, document as much as you can so that way it can be transferred without having a 100% necessity on hiring the people associated with it. Sometimes that works.
Yeah, I think that's the right advice. And I found out that a way to force them to do that and at the same time to give them time to decide whether they want to keep the trade secret protection or go the patent route is oftentimes to file a provisional, because it acts as a forcing function to document the innovation, whether it's an invention or a trade secret. And then you get a year to decide, basically, am I going to keep that as a trade secret? If so, I don't do anything after a year, and then I have a nice document, date stamp, that shows that this is our trade secret, and you can make sure employees know that it's, it belongs to the corporation. Or if you want to then go with a non-provisional, you've got obviously the earlier priority date, and then you can do your prior art search, before spending more money and filing the non-provisional. So for startups who don't always know what they're going to do and what the best strategy is, having a year of hindsight is huge. And if you have that forcing function to document, then obviously it helps with raising money or collateral funding. At the same time, you keep all options open and you basically get a year of perspective by the time you have to make that decision. So I think it's a very inexpensive forcing function to document, because a lot of mistakes people make is they don't document their innovation. It's basically IQ, not IP. IQ in the head of employees, and then when people leave, the IQ leaves the door. And there's nothing that's being really protected by the company. So that's a way to force that to happen.
Yeah, that's actually a very good point. I mean, Nathan probably does more of that, but I occasionally from time to time get into a trade secret litigation case. And for example, one case I recently worked on involved there are no patents in it. The two guys developed the same app, and one of them had access to the testing and like A/B testing and things like that are really important in software development of the other guy, and it gave him a head start in the market, and he got all the users, the other guy didn't get it. So trade secrets, I mean, it's a little nebulous to put your arms around it. I don't know, Nathan, you can speak a little about like the damages side of it.
It is nebulous, and that can be very good when you're a plaintiff, because you can sort of design your trade secret to match the bad conduct that you're going after, that you're enforcing. So there can be a bit of a downside to documentation in a way, because your documentation would be discoverable in the litigation, and you may find yourself with less flexibility to sort of meet what the conduct that you're accusing is. But I don't disagree with Brian's general principle that you need to know what the trade secrets are. If you want to enforce them, you will need to disclose them. You'll disclose them under a very secure court order, protective order, and all that kind of stuff. But at some point, in most jurisdictions, you need to really nail down what the trade secret is, and it needs to be pretty particular. So documenting what it is can be very important. And you certainly don't want to be in a situation where it looks in litigation like you've completely made up the trade secret just to match what your adversary is doing. So documentation can solve that problem as well.
I have a question for you, Nathan. Back in the day, I can't remember the year, I think it was the CTO of HP went over to become the CTO of Oracle. I think it was the year, I don't remember the year, 2008 or something. And HP got pissed off because they pointed to inevitable disclosure. which is basically this guy knows so much information that we're going to stop this from happening from you hiring him because you've got this. It's inevitable he's going to disclose these trade secret information or whether it's most coveted information. Have you seen any cases in that in your practice?
So I'm largely a California lawyer, and California does not recognize the inevitable disclosure doctrine. It's part of California's general public policy towards employee mobility and the ability of people to move from place to place. There's some exceptions to that. You know, partial or complete sale of a business can get around the employee mobility issues. And then if the employee takes anything, that would be a glaring exception to employee mobility, because likely they've breached a contract, they may have misappropriated a trade secret, and you can pursue people who've engaged in that kind of conduct. But just moving from place to place in California is not actionable. In other states, they may allow it, but I think generally, and I haven't done a survey on this, so you can disagree with me during the coffee breaks. I think generally it's becoming more of a disfavored doctrine because it's really hard to hold people accountable for what's in their heads.
The more important trade secrets are, the more disfavorable it is.
It is enforceable in Washington State, though. And when I was at Microsoft, my direct client, because I supported all the research labs, Kai-Fu Lee, who was in charge of the Beijing lab, went from Microsoft to Google, I believe, in a very high position. And although he was based in Beijing, his contract was under Washington state law, and they basically went after him on that inevitable disclosure law. And I think as a result, he had to kind of take a breather and have a cool-off period where he did something else, arguably, for a year until the non-compete or the confidentiality agreement was, the period had expired. But it can be enforced in other states. California is a bit of an outlier on this.
Yeah, you have to look. So, the FTC tried to ban non-competes nationally recently, and that was stopped.
It was stopped.
And Washington, they changed their law. So employees that make under around $150,000 a year are not subject to those restrictions. It's the higher paid executives, people like that are still subject to those restrictions. And I think, as consumer advocates or employment, the plaintiff's employment bar pushes legislation and things along those lines nationwide, you'll see more restrictions, particularly on more lower paid positions, as to whether or not you can enforce non-competes or inevitable disclosure type of claims.
Which is one more reason to be,
Questions? We're running.
You have another 15 minutes?
10 minutes.
10 minutes, okay. Louis,
I was just going to say, one more reason to really, if employees can move freely and you cannot go after them from a non-compete standpoint, the importance of documenting not only successes, but more importantly, failures in the company is extremely important. Because if, just imagine, an employee goes to one of your competitors or becomes one, and then let's say goes to one of your competitors and the competitor said, well, we'd like to try this approach. And the employee will say, well, we just tried it on my former place for 3 years and it didn't work. So you just saved your competitor 3 years of R&D, right? We're talking about barriers, barriers to entry. So all the things that didn't work are basically up for grabs. You can save millions of dollars to
Negative know-how. It's called negative know-how.
Well, it's negative know-how, yeah, but it's extremely valuable. So people usually don't think about this. I said, document your failures and make sure that employees know that they are proprietary information. They cannot share that because it's too tempting to ask a new employee what didn't work, or otherwise we won't try it. We'll save ourselves all these.
That's the example I was talking about exactly. Like if you're testing software, for example, and you know it doesn't work.
That was a good example.
That is a trade secret. Okay, any questions? Yes.
So I want to address a fundamental tension that you brought up, which is on the one hand, we don't have injunctions in the U.S. But on the other hand,
no interlocutory injunctions.
What's that?
Yes.
Patent injunctions. I don't get to patent. Very hard to get injunctions. On the other hand, only 1% of patents are any good. And as a patent attorney, let me apologize on behalf of my entire cadre. If there was any other industry in which you had a 1% success rate, that would be terrible. So I apologize. Now, that said, if only 1% is any good, then maybe the the inability to get injunctions is the right balance, right? Because otherwise we would give too much power to crappy patents. So how do you balance that?
Yeah, well, you know, I hate the expression crappy patents because there's so much Darwinism around patents these days that the only ones that will ever go to court are the best of the best of the best, the cream of the crop. There's no crappy patent. I mean, take away Bill Ramey and then a couple of attorneys who are still, you know, doing this kind of stuff. 99% of what's being asserted is very high-grade patents, very, very important inventions. So I don't think the issue here is patent quality or the injunctive relief, you know, reflects the fact that there's so few good patents. If there were better patents that were assertable, and there are a lot of them that are assertable, they're sold for a pittance because you cannot get an injunction. And if you lose their assertion value, the only thing you can basically recoup is damages, and damages are being obviously decreased significantly because you have to go through litigation, and it's fraught with risk. You know, they have an 80% chance of getting your patents invalidated through the IPR, and then if you succeed there, then you still have all the issues going through the court system. If God forbid you're transferred from Texas to Northern District of California, where patents go to die, you're toast. So we have a very inefficient and I would say heterogeneous system in the U.S. that creates all these uncertainties. So I think, and I've seen, you know, I was at Microsoft when people would basically, you know, throw a patent in our legs and say, if you don't pay me, you know, $1 billion, you won't be able to ship Windows 95. So it can be abused, you know. So there's got to be some tests for making sure that it's not the case. But I think, you know, fundamentally, you know, someone mentioned it's a right to exclude in the Constitution and in the law, in the patent law, and we've lost this here. And I think as a result, you know, it hasn't served the innovation community really well.
I would like to actually take exception with that. I don't know where the 1% came from. I think it's 1% that are enforceable in court, maybe. But I think we're losing sight because patents contribute in many ways to companies that are not always ending up in litigation. A lot of startups nowadays, actually, I see a huge rise in that, are the type of startup that files hundreds of patents and goes and raises funding on it is increasing a lot. So I think that there's maybe like a new life to patents that if we only think about it in the lens of litigation, well, I think we're losing sight a little bit of how patents are helping a business. But I don't know what others think about it, or Brian,
I mean, I agree there's non-litigation value to patents. I mean, just on a fundamental level, if you're practicing a technology in the industry publicly, we advise our clients to develop a patent portfolio just for defensive purposes. And there's value there as well.
That's what we're, that's what we're seeing from a value perspective. I mean, as I say, it's value in use. If the company they sell widgets and they've got you know, portfolio patents that cover those widgets, you know, they have an exclusive right to exclude others. There's value in that because you can directly attribute those patent claims to the revenue stream of the company. Right, there's a one-to-one correlation, the value in use, and then you're looking at that valuation as the company moves along to the next generation products and continue to develop more patents. So it's a portfolio approach. But I agree with you. There's still a tremendous value there.
Question in the back.
Yeah, on that 1% number. So in the economic literature, it's about 5 to 8% of patents have net economic value. That represents the value of the technology, not of the patent. It's just reflecting the fact that most new technologies turn out not to have commercial value. It's not that 99% of patents are crappy. It's just that we have very low predictive power of the value of a technology commercially in the market. So I think the 5 to 8% value doesn't cast any doubt on the necessity of an injunction.
Well, and that's why I said value in use.
Yeah,
a patent
that's exactly
is useful
yeah.
if it's in use, if that technology that's employed in those patents is being used by someone, there's value.
All right, I withdraw my apology on behalf of
No, I'm defending your profession.
So
My question was on the history of the different business models. do you see, as the protectability of patents has declined, you see patenting basically becoming a game for the rich, for the big company, and the licensing model for a startup becomes unattractive because VC investors won't invest in it? Do you observe that?
Not at all. I mean, I jotted it down last night, so that's not I would say a scientific historic overview. This is just my view, but no, not at all. I see patents being filed by it's really an industry question. First and foremost, there's two things to answer your question. It's the business model and the industry. You're not going to see a software company leading with patents ever. If you're a software company leading with patents, you're doing the wrong thing. If you want to get funding, you need users. You need users and recurring revenues if you're in the SaaS business. If you're a biotech company and you don't have patents, you have no business being a biotech company. It's because of the size of the R&D and the business model, which as a biotech startup, you're starting out, you're never going to grow. You're going to sell or license there's like 10 big companies that buy everyone, okay? You can also go IPO earlier without revenues because you don't have access to VC capital. It's very different from a software company. So it's really a question of the business model. How critical are patents to your business model? That's not to say that you don't need patents. You know, and Louis, I mean, if you continue on that.
No, it's a very good point. And I would contrast, there are really two business models that are working in parallel. And I call them wholesale licensing and retail licensing. Wholesale licensing, think of Nokia, Ericsson, Huawei, all these large patent holders who have hundreds and not thousands of standard essential patents. Their business model is to create enough of these so that basically they're ubiquitous and they're standardized and they get billions in licensing revenues out of those. This is their business model. They don't build products necessarily, they build patent portfolios for monetization. Startups are completely at the other end of the spectrum. They don't build patent portfolios to monetize these patents. They build them to create barriers to entry, to show that they innovated, and basically to try to deter new entrants so that they don't go from 100% to 50% market share the minute there's a second entrant in the same field. Monetizing their patents is usually an afterthought. It's mostly if they stop practicing them or they failed commercially. That's why you have maybe just 90% of startups fail, and the patents that are asserted are usually the ones that from companies that did fail, where we're trying to look, okay, all we have left are the patents, can we do something with that? And that's where people come, knock at our door and ask, is there anything we can monetize here? Because the company is not using them anymore, or they pivoted, or they're bankrupt.
And I would say the ability to do something with the patents at the end of the day has nothing to do, has a lot to do with how the industry evolved. And very
now, one last thought on that is you mentioned the VCs as far as startups not being able to get funding or whatever, that's definitely changed. I think in the last 10, 15 years, VCs had previously checked the box. In other words, you got patents, they checked it, say, great, okay, let's move on. And really didn't attribute any value associated with that. So there's been a lot of education that's happened, not just through Aon and what we're doing here, but a lot of IP-based lenders and just generally to the VC community and investment banking that there is value. And so you just have to make that leap of faith and make that transition and say, okay, they've got a portfolio of IP, whether it's a combination of trade secrets and patents, and you have to reflect what that value is to the revenue stream of the company. And that's valuable to a VC, and it does often open other doors that the startups might not necessarily have had before, because there's a lot more eye-opening to these investment communities that there is value.
Any more questions? Yes.
One more.
Should I go?
Yeah.
Okay, so this is a little bit of a reframing and a comment and a question. So going back to the first question, which was around reliability, I was thinking, what if we reframe reliability in terms of risk and think of it as a financial asset? And from that point of view, if we think of the risk-free asset being something like 10-year bonds or 20-year bonds, 4% interest, where do patents lie on that spectrum of risk? And if we look at what the returns are that investors need in order to invest in patents, it seems to be over 100%, right? So that kind of gives it, if we think of it in that risk spectrum, that kind of gives you a sense for how reliable patents are relative to other financial assets. And it would be interesting, at least from my point of view, to see if over time that rate of return that's required has decreased.
I mean, I have a quick answer to that. Some people might look at and just think about patent, generally IP. Some people think about IP as an annuity. If you're licensing a brand, like I know David Bowie securitized his name, like that is risk-free, right? Some people used to think about IP as a stock option. I lived through those days about 10, 15 years ago when companies came out with all these products. It doesn't work because there's no underlying asset like a stock. If you know anything about Black-Scholes model, that's not how you model a patent. There's no underlying asset you can look to peg the value to.
There's no floor, right?
There's no volatility of the stock. Then you need to plug in this. So those were not very successful.
A patent's 100% of something, but most of the time, 99% of the time, it's nothing that it's 100% of.
Okay, Louis, and
Well,
I let everybody
I mean,
else respond.
Still, we have to remember, we whine and bitch about patent valuations being very low, but for the most part, people will pay about $50,000 to acquire a patent or a small patent family, and 10, 15 years later, it might sell for about $250,000 for the same asset. So I don't know, I'm not a math guy, but it sounds like to me it's a better return than if you just have a 4 or 5% annual interest rate. So obviously, it's not going to happen with all your patents, but there's still value if you look at it compared to a bonds or buying stock. There's still value, except that's really not what most people file patents for. So it's really, again, a byproduct of other things that have not worked, or people having copied obviously the innovator here, and then you say, well, someone should pay me for that, and then you can still practice and recoup some of the licensing revenues. But it's not a bad investment, but obviously you don't have the same predictability to what it's going to be. And most patents will be between 12 and 18 years old. So it's not something that happens overnight either.
Okay.
Well, I know, Bruce, we're over time, but one last thought.
Quickly.
Look at it from this whole value in use. So when we looked at IBM, the risk of default for a company defaulting, right? So they have a loan, 4-year term loan. There's a risk of default. And so what we did was you plan the divorce before the wedding. So in other words, what you do is you look at what is that value at the end of the day if that company defaulted. And so that's when you point to an acquirer that has in use, or perhaps an acquirer could be used to adopt those patents and put on another product stream or whatever. But so there is a way to determine that value, looking at a risk element and calculating what that value is.
Great. Thank you very much.
Yeah.
Thank you.
Thank you to the panel.